Mr. Meiklejohn.
Well, at least I think I have a name that if I had a Facebook account, it would be easy to find, but like Mr. Johnson.
You mean that wasn't yours that I looked at? I'm sorry.
I'm not the only Tom Meiklejohn around, but I'm going to start by talking about a case I had a few years ago, where Excelsior list, in accordance with the current standards, was provided to the union, and it was replete with incorrect addresses. And it was filled with incorrect addresses, not because the employer was trying to hide anything or make the campaign more difficult for the union. It was because the employer didn't bother to keep them up to date, because the employer didn't use the addresses to communicate with the employees. When Excelsior underwear was decided before all of our times, addresses and the mail and personal visits were the vehicles for visiting and communicating with employees. It's, as Mr. Torres has acknowledged, recognized, or advocated, communications methods have changed, and they're changing rapidly. And he certainly points out that in the future, there may be a need to update this rule further. But today, in 2013, this is or email addresses in particular, are one of the principal means by which people communicate. And I don't believe anybody has identified any reasons why that vehicle shouldn't be available to unions on an equal basis. If the employer has that information, why they shouldn't have to share it so that both sides can communicate. It is not an invasion of the employer's property on the order of the union having an opportunity to speak to the employees in the plant. If we were trying to have an equal system, it seems like that would certainly be the place to start, would be having both sides have the opportunity to have face-to-face communications at work. We're talking about a method that does not involve a significant invasion of the employer's property, and does not, certainly has less danger of invading the employee's privacy compared to home addresses. If I get an email that I don't like, I think this point has been made many times, but it's much easier to deal with than somebody who's on my doorstep. I don't even believe there have been any real significant accusations that unions have used home addresses for any purposes other than to campaign. And I don't believe that there's a need, or any need been demonstrated in 2013 to add a regulation that would restrict union, 2014, I don't know where I lost the year there, didn't I?
It is a bit of a reboot.
Yes, okay. There's no reason to impose a restriction on the use of the Excelsior information just because it's going to include emails or telephone numbers where there's no history of this kind of misuse, and where, as has been pointed out, the board is really not in a position to enforce I think you understand I'm talking about the last sentence of the rule that would limit it to purposes related to the representation case and related purposes. There's been no demonstration of a need for that. There's no reason to believe that unions are going to misuse the information. I have one example of a case that's going on right now that illustrates the problems that would be confronted in implementing that regulation. About 5 or 6 months ago, a union lost an election. One of my clients lost the election by a tie vote. So the union has obviously an interest in staying in touch with the employees and the expectation that the employer won't keep its promises, perhaps. But whatever, that they have an interest in staying in touch. The employer appears to have embarked on a campaign of weeding out the employees who identified themselves as union advocates. We filed charges over the discharge of the person who served as the observer in the election. And we need to contact witnesses to support certain aspects of his story. Now, would it be a violation of this regulation if we were to use the Excelsior list from 6 months ago, assuming the new regulation was in place, of course, if we were to use that Excelsior list from 6 months ago to contact witnesses and to try to convince them to give an affidavit to the board? I think you're creating many potential areas of dispute, fine distinctions where you have no real method to enforce it and where there is no real problem.
Thank you.
Mr. Meiklejohn, just one quick question. If you were in our positions, do you think work email addresses and personal email addresses are the same? Was one more important than the other? Work email addresses give rise to the treatment of company information technology, resources policies, other kinds of surveillance type issues potentially. What are your thoughts about that?
Well, it's hard to put myself in my own position. If both are available, I would advise my clients to use the personal email addresses to communicate with the employees, not to communicate through the employer email addresses for the reasons that you've just identified. The reason why I think both are needed is, well, twofold. One, because in many cases the employer may not have personal email addresses. And the other is that there may be circumstances in which there are employees who set up personal email addresses but then are not in the habit of regularly consulting their personal email addresses. Yeah. That would be me also. I read my work email much more regularly than I do my personal emails.
Okay, thank you.
Should we change the miss rate rule basically for the Excelsior list where it's personal emails that sometimes the employer has no occasion to see whether they're accurate or not?
I'm sorry, should you change the what rate?
Well, for example, if the Excelsior list is inaccurate, right, we have certain standards when it's basically the home addresses. Should that be a more lenient standard if it's personal email addresses? Because those typically can sit uncorrected for years with an employer.
I mean, I don't recall the exact standards, but my recollection is that the information has to be pretty close. The list has to be pretty bad before it will result in overturning the election, unless there's some indication that it was deliberate. It's in my testimony from 2.5 years ago what the percentages were in that case that I referred to, but I think there were more than 10% of the addresses that were bad, and it didn't result in overturning the election because it wasn't deliberate. But I don't remember exactly what the standards are. I don't think that's something that can be addressed in the rules, but when the objections are filed, there would be a need to look at the issue on a case-by-case basis. Is the information inaccurate enough to warrant setting aside the election or not?
Okay.
I think it would be one situation if, the address was right, the phone number was right, but some of the email addresses were wrong. It's a different situation if all the information is inaccurate. But I don't come here. I don't have a client that I have to refer to, fortunately, but I haven't figured out exactly what those standards should
We just have to move on.
Yeah.
Okay.
Thank you.